are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show covers the intersection of tort law and trust law. With us now is attorney Thomas Greer of Bailey Greer. Thomas, thanks for being with us today. And I think the place to start with this in couching it, since we've got an intersection of two types of law, I know when I have clients come to me, a lot of times they think, well, you're an attorney, you should be able to do anything. And I think really what they misunderstand is attorneys are like physicians. There's some that are general practitioners and there's some that they practice in a specific area of the law. I know I practice a lot in trust and estate planning, and you practice a lot in tort law. So I think if we identify what tort law is, that gets us off to a good start.
Sure. So, as you said, my area of practice is a tort law, and that would be anytime somebody is injured. So it can be a car wreck case, a medical malpractice case. It can be where somebody gets injured on property or something like that. That's my area of practice, and as you said, lawyers are legally, we can take any case. So there's no restriction on that. If somebody comes into my office and they say, I want you to draft a trust document, I can technically do it, but it would not be a very good idea for me to do something that's sort of out of my wheelhouse. And so very often clients will come to me, and I'm sure they come to you, and you say, well, I appreciate you coming to me, but that's not really my area. And you'll send them to an attorney who's more qualified or who specializes more in that area.
Mm-hmm. Yeah, and I think that's always the interesting thing with these things, because I know I get folks that come in and they're like, oh, I saw on TV that I took this drug and I can now get part of a settlement. And I'm like, I don't do any of that. Here are 3 numbers of attorneys that do that you can call. Mm-hmm. And I think it's important that folks understand that. And I think the intersection of our two areas of law winds up in well, for me, most people that would come to me for trust work or estate planning would say, well, how does that intersect with an injury or some sort of accident? And I think really what we get into is when we have sort of the severe torts. And maybe you can talk a little bit as to how those arise, and then we can get into the intersection.
Sure. You know, every case is different when somebody's hurt. Sometimes it may be something that's minor, they have a broken leg or something that they can recover from. But oftentimes the injury is what I term as catastrophic. Something where the client is never going to get over it, where the injured party is going to have medical care the rest of his life, her life, never live independently. So cases that I've handled over the years would include things like a birth injury where a child is brain damaged during the labor and delivery process and they're catastrophically injured. I had a case recently where an inmate was in prison and he was supposed to be given blood pressure medication. They didn't give him his blood pressure medication. He had a stroke and he'll never be the same. So these are things that are where the injury is very serious. They're never going to get over it. And if you can get a case like that resolved, that's, I think, when the trust comes into play, because people who are catastrophically injured, they can't manage their money. They can't manage themselves or provide housing for themselves, things like that.
Yeah, and sometimes it's that they're injured so severely that they wouldn't be able to manage their day-to-day check writing or anything like that, or they may be so young. So that's one time where you may need a trust with it. But then the other thing is the federal government has recognized that on certain disability payments that we get, that you can still be compensated for the care, but you can put it into specific trust, draft a certain way, and created by the court with court approval, to where in those trusts, the funds are not counted as an asset, thus knocking you off of disability or 10 cares we have in Tennessee or things of that nature. And some people always, when I have these conversations, they're like, really, you can do that? Doesn't that seem like double dipping? And I'm sure you've heard some of that too. But really what every one of these trusts are, it's got a provision that the federal government's put in there that says you have to, upon the party's death, you have to repay this money for any medicals that were paid for by the government.
Exactly. So in cases that I've handled, let's just take a birth injury case where the baby's brain damaged at birth. When that happens and the child's catastrophically injured, they become eligible for certain benefits through the government, TennCare and things like that. And a lot of it has to do with, it's income-based, or at least some of it is, and you probably know more about that than I do, but one of the things that I do as a personal injury lawyer, as somebody who practices tort laws, I sort of know my limits. So I know that if I'm able to get a verdict or get a settlement where I have gotten some money for my client to help provide for the medical care that they need the rest of their life, I'm not just going to hand that money over to the family and risk destroying these benefits. And so that's where I say, I know there's something called a special needs trust. I call you, you come in, you set the trust documents up. And then like you said, what that does is the money that goes into the special needs trust can only be used for certain qualified medical expenses. And then it allows the child to also have access to governmental benefits and education programs and things like that that are important.
Yeah, and that's one of those where I think those trusts are also very restrictive on what you can pay and what you can't pay, which we'll get into some more details of that in our next segment. When we return, we'll continue with our discussion on the intersection of tort law and trust law. Please stay with us.
Looks like it's done.
Don't let salmonella get funky with your chicken. On average, 1 in 6 Americans will get a foodborne illness this year. You can't see these microbes, but they might be there. So learn the right temperature to cook each type of meat. Keep your family safe at foodsafety.gov.
So who's going to do what?
I'll pack the dead batteries.
Great.
I'll only put what I don't need into a duffel bag.
Perfect. That's totally unhelpful.
No problem.
Meanwhile, I will try to comfort everyone by speaking in a calm voice. And who is going to handle supplies?
I can forget to do a list for us.
Thanks, pal.
We couldn't be any less prepared. I'm proud of you guys.
Talk to your kids about who to call, where to meet, what to pack. Visit ready.gov/kids for tips and information.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Thomas Greer of Bailey Greer. We're discussing the intersection of tort law and trust law. Thomas, before the break, we were talking about, these very severe torts where someone becomes disabled because of the actions of another party, and it qualifies them for benefits and everything, and then that we can take those settlements and put them into specific trusts and not destroy the benefits that they qualify for. And I think an important thing with that is somebody understanding that from the time of the occurrence of the event that gave rise to the legal action, what that timetable is before you actually get to this need of a trust.
Sure. As you can imagine, it's not like you see on TV where somebody walks into the lawyer and the next week they're having a trial and everything's over. It doesn't happen like that at all. Particularly with brain-damaged children, it can be a few years before the parents figure out that something, that there was a negligent act that may have led to the brain damage. Okay, so it may be a couple of years before you find out. By the way, Tennessee has the shortest time period of any state in the nation. It's pretty barbaric in Tennessee. You have the brain-damaged baby has 3 years to file a lawsuit, or they can never file a lawsuit. But that's an aside. So it may be a few years till you figure out what's going on, then you file your lawsuit, and it's going to take several years of litigation usually to take depositions and to get all the records that you need. But in the meantime, you want to sort of get an idea of what your client needs for the future. And so oftentimes we will employ people who are called life care planners. I usually like to try to find a life care planner who's also a doctor who can sort of map out what this child is going to need for the rest of his or her life, what kind of therapies the child will need, what kind of modifications to the house, what kind of medications, things like that. And then the hope is that ultimately we can prove our case and secure an amount of money that will then be used appropriately for the child and sort of incorporated back into the trust and give the trust guidance on how to spend the money. Because you want to, as you can imagine, if you secure money for a 4 or 5 year old child that has a normal life expectancy, you have to try to make that money work for them for the rest of their life.
Yeah, and I think it's an interesting thing because when you implement the trust with it, there's certain technical regulations that have to be followed with that trust. Because I can recall one December we had a newly elected judge to the bench, and I had to go back and forth for 4 days explaining to that judge the settlement check must be cut to the special needs trust. It cannot flow through the attorney's account and be made out to the beneficiary of the special needs trust. Otherwise, the federal regulations say that they are disqualified from any federal benefits because they have too many assets. And I think it's that's the understanding of it, that it's a very technical thing, whereas I would not be able to go in and try a severe tort case. I might be able to try a little fender bender, but even that I would still prefer somebody else trying it than myself. But with this, it's just like you're very good in trial, and you're smart enough to know, hey, go get the trust attorney to draft this, because I know all the little ticky-tacky details with it, and then I'm able to explain that to the judge. We've got most of these documents are 28 pages, and they tell the trustee what they can and can't do, that it's to supplement.
Well, it goes back to I think your initial point that lawyers more and more are becoming specialized, and one of the things that attorneys need to know is what their limits are. And so anytime a lawyer starts going sort of outside of their limits or outside their comfort zone, it's really a danger to the client. Just like you said, if a lawyer was not experienced in catastrophic torts, they may get that settlement money in, put it in their escrow account, and not even know that that's ruined benefits, lifetime benefits for the child. So it's just, I guess it's just an important thing for people to look for an attorney, is somebody who knows their limits and knows when to step back and say, I'm not qualified to do that, let's get somebody else in here to help us.
Right, and I actually had a call in the past couple of weeks from an attorney in Tennessee that, he knew his limits and was asking, he knew he needed a special needs trust in here, but he didn't quite know what type he needed, because there's two flavors of it. There's a pooled trust that's for smaller trusts where you can pull all of the money together. It does the same thing, but the attorney's fees for creating it aren't as much, and there's a better interest rate on that small amount of money than what would be in its own trust. But it was interesting in my conversation with that attorney, he knew what his client was wanting to do with the money, as far as a house and some things like this, but he wasn't sure as to whether or not they could actually purchase these things. Because I think it's pretty broad as to what the supplemental needs trust can be used for. And when I draft one, I always send the trustee a pretty detailed letter of the things that we know are okay, and then give them some guidance as to what else could be a supplemental need. And I think that that's the other interesting piece of these trusts too, are you still got to deal with that trustee and figure out, the individual that's caring for the injured party, or is the injured party, is going to have to go to that trustee and say, hey, this is what I need. you know, I need a car to get to and from the doctor. And then the trustees say, well, okay, a Camry's reasonable with this. Let's go buy you a Camry as opposed to a Mercedes or something of that nature.
Right, and I think just to let your viewers know that a trustee would usually be something like a bank or someone other than just giving money to the mom or the dad, because you want sort of a separation between the parties, and you want somebody that's going to be responsible for the catastrophically injured person's money. And so that's another part of doing the kind of work I do and that you do, is a sort of, I'll work the case up to a certain point, hopefully we have a successful result, and then there's sort of a handoff where lawyers like you come in and make sure that, you know, I may have worked on the case for 3 or 4 years, but the documents that y'all put in place and the restrictions and the protections that you put in place, they've got to last, you know, sometimes 40, 50 years into the future. So.
Right, and I think the other important part of that, though, is as part of the intersection with it is the communication between your office and my office, which has always been good as far as, okay, what is it that needs to be provided with this? And that's where, in having that life plan that's been worked up, we know, and then we can kind of look at these trusts and items like that and say, okay, well, we know what the life expectancy is. We know kind of where this should be invested, things of that nature, and then whether or not, you know, are we going to get them a condo, are we going to get them an apartment, you know, things of that. And that's where it is interesting, because in these trusts, and this is another thing that's, I think is important, you generally want a trustee who's just doing the trust duties, you know, as far as the management of everything, but that they've got the funds invested with someone else that is independent of them, making sound investments that are where the trustee has approved of that. And I think that sometimes there can be a bit of a rub when we get a bank involved that wants to manage the funds and be the trustee, because to me there's an inherent conflict of interest there of, well, if I'm managing the funds and I'm doing this, I'm going to generate more fees that I can be paid off of and things of that nature, as opposed to having a separation of powers.
That's exactly right. It's another layer of protection that you want to build into these kind of trusts. Anytime there's a large amount of money anywhere, you have people that sort of want to get their hands on it. I'm not saying it in a pejorative sense that the banks do it intentionally, but like you said, if a bank is making decisions on how to spend the money and they're also making fees on how they manage it, then they have an inclination to want to hold on to their money and not provide it to the person who deserves it and who needs it. Another thing that sort of came to my mind as you were talking with these trusts and how helpful they are is it takes the decision making out of the hands of the parents. Now the parents usually will work.
I hate to cut you off, but we need to cut to a break. When we return from our break, we'll talk more with Thomas Greer about the intersection of tort law and trust law. Please stay with us.
So, same time next week?
Well, of course. Put away a few bucks, feel like $1 million. For free tips to help you save, go to Feed the Pig.
They're coming. Places, everybody.
Light check. 1, 2, 1, 2.
Everything looks good on our end.
And lights.
Come alive with the forest. Visit discovertheforest.org to find a forest near you.
Welcome back. With us now is Thomas Greer, and we are talking about the intersection of tort law and trust law. Thomas, before the break, we were getting into kind of having these sorts of trusts are good because it helps the decision making with what to do with money and take some of that burden off of the folks that are having to care for the injured party. Now, if someone's been injured in one of these catastrophic torts and they're trying to figure out who to go to and interviewing attorneys, what are some questions that they should ask to figure out if they've got somebody that's competent?
Sure. I mean, just like you pick a doctor or somebody else in your life that's important, if someone's faced with a lifelong catastrophic injury that they're going to have to deal with forever, you want to make sure you get the best lawyer. And so anytime you go and interview lawyers, you're going to want to know what kind of experience do they have? Have they handled cases like this? You're going to want to know, have they actually tried cases? Because if you go to a lawyer who has never stepped foot in a courtroom and doesn't know how to try a jury trial, the other side knows that too, and you have a lot less leverage with an inexperienced lawyer on that front. But to sort of segue back into what we're talking about, you also need to ask questions about what happens when we get money. Let's think long term. You need to have a lawyer who understands those kind of things. So you can ask questions about their experience, their trial experience, their track record. I think another important question is, how many cases do you have? I try to limit the number of cases that I have so I can know each and every one of my clients. They can reach me on the phone if they need me. But beyond that, does the lawyer know enough about what he's doing or what she's doing to protect the money in the long run? And so if somebody ever asks me questions about that, about what happens with the money, I can tell them a little bit about it. I can tell them generally what a special needs trust is. But what I'm going to tell them is, when that time comes, I'm not the guy. I'm going to set you up with somebody else to make darn sure that we take care of the money for whoever is injured. It would be it a child or an adult or what have you.
Yeah, and I think that's always, this is my telltale sign on whether I'm dealing with somebody that really knows what they're talking about or not. And it's, if they're willing to admit, one, that they have got to bring in help, that's always a good sign. The other part of it is, and this just makes me think of, I got called to I had an attorney ask me to do a special needs trust, and I explained to him, like, look, you got $90,000. This is what the client's going to end up with. That's going to be gone in a heartbeat. What you're going to pay in trustees' fees on an individual trust isn't going to make sense for them to have an individual one. So why don't we look at the pooled trust, and if you need me to do any of the drafting, feel free to come back to me, but here's a guy's number at Forge Consulting. These guys are really good. They do this day in, day out across the country. Talk with him, because, and that I think is always a good tell or a good sign. If an attorney is willing to say, hey, go talk to other attorneys, find one you're comfortable with, then they're probably a better attorney than the one that's sitting there going, oh, don't talk to anybody else. You just need to sign right here.
Right. Well, I mean, it can be a challenge sometimes for attorneys who may have a client in front of them that the attorney sees, well, I can make some money on this, or I can get paid. And so there's a temptation there to try, for some attorneys, to try to hold on to maybe more than they should. So it's just a fair point that I think we've tried to make during this program, and there's a lot of overlapping areas in the law, but it's just important for your attorneys to know what their limits are and to know the pitfalls of your case. Most people who are injured, obviously, that they don't have the catastrophically injured, they may not have the wherewithal to know anything. They may be dependent on others, but they're caretakers. They're not going to know what a trust is. They're not going to know what these things are. And unless they're guided in the right direction, then a lot of harm can be done.
Yeah, and I think that's the other important thing to also, when it comes time that other advisor's in the room, being sure that you've got the ability to have FaceTime with them to ask questions. Am I going to be able to spend it on this? Am I going to be able to spend it on that? Because to me, managing expectations on the front end of what the trust is going to do becomes very important. Whereas when I deal with you or Russell Lewis, I've worked with you guys in the past, so I know you have knowledge to educate. Whereas some other folks, when they call me up, I'm like, okay, well, wait a minute, we need to all sit down and talk about this so everybody's clear. Because what I don't want is somebody to be upset with them because they brought them to me and they just didn't know what was going on.
Absolutely. It's talking about managing expectations. There are sort of downsides sometimes to special needs trusts. I've had older clients who physically would qualify for a special needs trust, but mentally they're fine. And I'm telling them, put your money in a trust, but there's going to be pitfalls. You're not going to have access to it. You're going to get mad at me after we do this because you're going to want that big screen TV.
Right.
And the bank's going to tell you no, but look, trust me, it's for your own good. We want this money to be around for a long time, so you do need to tell them that on the front end for sure.
Yeah, and I think that everybody in this world, whether it be a 2-year-old or a 90-year-old, if you sit them down and kind of give them the expectations, then they're just better off for it.
Yeah, and tell them what the benefit is. And
yeah, and you know, I've had to do that with my little one before. You know, doesn't want you to leave, but I say, okay, now look, this is where I'm going, and this is what I'm doing, and I'll be right back. And he's like, oh, okay, I can deal with that. I think clients are very much the same. If they know on the front end, then everything's okay.
It's human nature. Nobody wants to be surprised, no matter if you're a child or an adult. It's just human nature. You want to know on the front end what I'm getting. You don't want to be surprised down the road in any part of life.
Well, and I think our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman, and thank you for watching.